Good afternoon, sir.
Sir, very good afternoon. Happy afternoon,
How are
sir.
you, sir? Happy
Good.
afternoon.
Good afternoon, sir.
Happy. Shall we start, sir?
Yes, sir, we'll start. 1 minute, sir. One small introduction will be there. 1 minute,
Ah.
sir, please wait.
Okay.
Hello, shall we begin?
Yes, Josna, I'm hearing. You may start.
Okay, sir. I hope I am audible to everyone. A warm good afternoon to all. Since everyone is here, we should get started. Myself, Joshna Joseph, and also Praveen Varghese, lecturers in KMP College of Pharmacy, will your host for the day. Respected Principal J. Nandakumar Sir, Honorable Chief Guest, Dr. V. Gopal, Registrar and Principal College of Pharmacy, the Mother Teresa PG and Research Institute of Health Science, Puducherry, and teachers and all my dear friends. Thank you all for joining with us for the national webinar organized by IEDC and IIC of KP College of Pharmacy on the topic Understanding Intellectual Property Rights and Importance of IP Management for the Startup.
The Innovation and Entrepreneurship Development Center is a platform that is set up in engineering, management, arts, and science colleges, and also for the medical institutions, also the polytechnic as well, with an aim that provides students with that as an opportunity to experiment and also to innovate. Now, let me call upon our beloved principal, Dr. J. Nandakumar Sir, to introduce the speaker. Sir, please.
So, thank you, Josna and Praveen Varghese, for this starting and introduction. So, happy afternoon to everyone gathered for this national level webinar. It's my enormous pleasure and privilege to welcome all of you for this webinar on behalf of KMP College of Pharmacy and my own behalf. The given task to me is to introduce our today's speaker, Dr. V. Gopal. Presently, Sir affiliated with the Mother Teresa Postgraduate and Research Institute of Health Sciences, Puducherry, in the stream of pharmacy, associated as Registrar in Academics and Principal to Pharmacy College. Dr. V. Gopal is Sir graduated from Government College of Pharmacy, Bangalore, in the year 1990 and postgraduated from LM College of Pharmacy, Ahmedabad, Gujarat, in the year of 1992. Further completed doctorate from Gujarat University in the year of 1996. Completed MBA from Alagappa University, Karaikudi, Tamil Nadu in the year of 2008 and completed postgraduate diploma in computer applications, and he is having more than 30 years of experience in teaching and research. Gopal sir honored with 23 awards like Best Academic Administrator Award 2021, Best Scientific Speaker of the Year 2021, Eminent Teacher Award 2020, Marundiyal Mamani Award 2014, Saiva Tamil Pullavar Award 2009, etc. He was having various professional positions during his service. Ex-chairman of the Education Regulation Committee and Central Council, ex-member Pharmacy Council of India, ex-member of Ethics Committee, ex-member of AICTE for UG and PG courses in pharmacy, nominated as member by Government of India for Siddha Pharmacobial Committee, and so on. He is the approved PhD guide from 9 universities and produced 27 number of PhD scholars. Published more than 184 papers, research publications. And Sir received grants rupees 17 lakhs, 70 lakhs, 70 lakhs, and 60,000 from Government of India under various platforms like Department of Science and Technology, Central Council of Research in Siddha and Ministry of Ayush, etc. So he is having a versatile experience in the field of pharmacognosy. Apart from these activities, he is also an editorial board member in various national and international journals. Like the way, if you are speaking about SARS experience and overall profile, it will extend more than half an hour. So I want to cut off up to this level. Now, I hope you may have a wonderful session with Dr. V. Gopal about the entrepreneurship development and its aspects. Thank you, Ananda.
Happy afternoon to
Sir,
one
now
and
you
all.
may start.
Happy afternoon to one and all. Am I visible? Am I audible?
Yes, sir,
Yes,
you're
sir.
audible.
Thank you. At the outset, I thank the principal of this prestigious institution for having organized this national webinar in a scientific and a systematic manner. Thank you very much, sir, for the nice introduction. Today, the next 1 hour, we are going to deal about a topic, understanding the intellectual property rights and importance of intellectual property management for startup. Can I have my first slide, please? Admin, please share the PPT. Hello?
1 minute, sir.
Thank you. You can go to slideshow. Please go to the next slide. Yeah, thank you. So, my dear participants, you are seeing here the photograph of Mr. Gopala Krishna Nair. So, I am starting this session with Mr. Gopala Krishna Nair, who is a live example of my topic, understanding the intellectual property rights and the importance of intellectual property management for startup. So this entire topic can be well explained with his life. Next slide, please. Mr. Gopalakrishna Nair, he started a startup, and because of his interest in intellectual property rights and because of his excellent intellectual property management, he has become very popular throughout India and abroad. Mr. Gopalakrishna Nair is a postgraduate in chemistry, and he was doing his personal research. When he was doing his research on herbal medicine, he used to wash the utensils used for research by himself. And one day he observed that there was hair growth in between his fingers, and this prompted him to investigate on what research he is doing. He was doing research on an herbal oil, and when he voluntarily placed the oil on his wrist, he noted that there was hair growth, and the hair growth was very rigorous. So then he thought this oil could be very useful for treating baldness. He started doing research on male pattern baldness, and his Ayurvedic oil became very popular, which was selling 60,000 bottles abroad without any advertisement. But he never let know anybody else about his product. He was continuously updating his product, and he was testing his products on his kith and kin. Accidentally, one national or international politician came to know about this product, and he tested it on himself, and he found that it had excellent results. So because of that, his product was flashed in the media, and in 1989, there was an overwhelming response for his product. One very big corporate company, I don't know whether I can say its name here, taking it as a closed circle, I will say it is Godrej. So this company approached him and requested him that they will collaborate in selling this product, but he did not immediately accept. So he asked them to wait for 1 year, and then he gave his product to that company. Next slide, please. The demand for this product was very high. The corporate company and Mr. Gopalakrishnan Iyer named this product as Anoop, and this was manufactured by a handmade process which is fully automated in his own manufacturing unit. It is called Arshik Herbal Remedies, which is near Thiruvananthapuram. And after that, he has come out with various products. And now he is the state president of Ayurvedic Medicine Manufacturers Association, and he is the leader of Public Relations Association. Next slide, please. So he came out with an innovative idea, number one, and he wanted to make that innovative idea a commercially viable product. For that, he made a startup. And the name of the startup, just now I said, Arshik Herbal Remedies. And then he got a trademark filed for his product. And this was filed on 26th November 1990 in Kerala through Chennai Intellectual Property Office. So it was filed by one Mr. Veera Raghavan, and this is the application status. And this Anoop trademark and his interest in patenting his formulation has made him grow to this extent. But there is one problem. One important ingredient in his formulation is not available, and hence, the efficacy of that product is now not as it was in yesteryears. So with this introduction of a successful person who has started a startup, and because of his interest and knowledge in intellectual property rights, who has become very successful and who is having a very good intellectual property management skills. So now the question arises, what is intellectual property? Next slide, please. Intellectual property refers to creations of the mind. What are the creations of the mind? Inventions, literary work, artistic work, design, symbol, name, images that can be commercialized. Intellectual property is protected in law, by law, and for example, we have patent, we have copyright, trademark. So these and all are intellectual property protection tools which enable people to earn recognition or financial benefit from what they invent or create. Intellectual property laws, they strike the right balance between the interest of the innovator and the wider public interest, The intellectual property system aims to foster an environment in which creativity and innovation can flourish. So here, a person who has invented, so for his innovative thinking and for bringing it into practice, he need to be paid and his rights have to be protected. So that is intellectual property rights. Next slide, please. There are many types of intellectual property. We will take one by one. The first and the most foremost one is patent. What is a patent? A patent is an exclusive right granted for an invention. Generally speaking, a patent provides the patent owner with the right to decide how or whether the invention can be used by others. In exchange of this right, the patent owner makes technical information about the invention publicly available in the published patent document. In the beginning, we saw about Mr. Gopalakrishnan Nair. Similarly, many formulations have come into the market. So they are patented to protect the rights of the patent owner. But information about that product is available in the general public to the extent of the utility of the patent. Next slide, please. Next slide, please. Yeah, thank you. No, previous slide. There are a number of types of patent. The most popular among them is 3 types of patent. Technology companies commonly use patents as seen in the patent for the first computer to protect their investment in creating new and innovative products. So usually patents consist of 3 types. The first one is called as design patent. So protection for the aesthetics of a device or invention is called a design patent. Ornamental design patents include a product's shape. Like for example, Coca-Cola bottle shape is a design patent. Emojis, fonts, or any other distinct visual traits, all of them fall under the category of design patents. The next one is plant patents, safeguarding a new variety of plant. Like for example, a new variety of basmati rice. An example of a plant patent is pest-free version of fruit trees. But inventors may also want a design patent if the tree has unique visual properties. The third category is utility patent. This is protection for a product that serves a practical purpose and is useful. I can give you an example. Vehicle safety system, a software that is used as a statistical tool, a pharmaceutical product. So these and all come under this utility patent. Next slide, please. So what are patentable inventions? Patentable inventions, I can give you an example. If a company is coming out with a new drug to treat cancer, or if a mobile phone company is coming out with a new display system, if a vacuum cleaner manufacturing unit is coming out with a new suction system, a camera manufacturing unit is coming out with a new image processing and recording system, a pesticide company is coming out with a new formulation, a water purifying manufacturing company is coming out with a new method to purify water. So all these are patentable inventions. The criteria for registration of a patentable invention is: number one, novelty; number two, inventive phase; number three, it should be effective; and usually a patent protection is given for a period of 20 years. Next slide, please. So we will see what is the overall process for obtaining a patent protection. Number one is you need an idea or you need a concept. Number two, you should conduct a patentability search. Number three, you should file a patent application. Number four, the patent application has to be published. Number five, there are patent examiners. So your patent application will be sent to the patent examiner. He will examine your application and he will give a report. So based on that report, the patent could be granted or rejection. And finally, once the patent is awarded, the next is maintenance. You will have to maintain your patent. Next slide, please. I wish to give here a beautiful case study. In India, we have been using turmeric for ages. Turmeric is used as a medicine. Turmeric is used as a food. Turmeric is used as a dye in cosmetics. But in 1995, the United States awarded patent on turmeric to University of Mississippi Medical Center. Two scientists, both of them Indians, studied in India, learned about turmeric from India, went to America and got a patent for America against India, stating that turmeric can be used for its wound healing property. The claimed subject matter was the use of turmeric powder and its administration, both oral as well as topical, for wound healing. And exclusive right has been granted to sell and distribute this turmeric powder as a wound healing agent, both orally and topically. It was the period of Dr. Marshall Kerr, who was the director of Indian Council of Scientific and Industrial Research. And under his guidance, we had a beautiful team that objected to the patent granted and provided documented evidence of the prior art to USP Trade Office, that is United States Patent Trade Office. Though it is a well-known fact that in India we are using turmeric in every household for ages, but finding a published information on the use of turmeric powder through oral route and topical route as a wound healing was a Herculean task. It was very difficult. Due to extensive researches, after 6 months, we were able to produce 32 references located in different languages, namely Sanskrit, Urdu, Hindi. And after submitting all this, the United States Patent Trade Office revoked the patent, stating that the claims made in the patent were obvious and anticipated, and agreeing that the use of turmeric was an old art of healing wounds. Therefore, the traditional knowledge that belonged to India was safeguarded in turmeric case. So this is a very good example where you can see how important patent management is for each and every one of us. Next slide, please. Next, I would like to take up a case study on turmeric patent. Sorry, turmeric patent is over. Next slide, please. Can I have the next slide on neem patent? Yeah, thank you. So I would like to take the next case study on neem patent. The patent for neem was first filed by W.R. Grace and the Department of Agriculture in United States of America in European Patent Office. The said patent is a method of controlling fungi on plants comprising of contacting the fungi with a neem oil formulation. The legal opposition has been filed by India against the grant of the patent because in India we have been using neem as a pesticide since ages. The legal opposition to this patent was lodged by a New Delhi-based research foundation for science, technology, and ecology. So this Research Foundation for Science, Technology, and Ecology, in cooperation with the International Federation of Organic Agricultural Movements, and along with Magda Ayolet, former Green member of the European Parliament, they opposed giving patent to neem because neem has been used in India for various diseases as an antiseptic, as a toothbrush from time immemorial. The opponents, that is W.R. Grace and co. So they submitted evidence of ancient Indian Ayurvedic texts that have been described. The hydrophobic extracts of neem seeds were known and used for centuries in India. So we need to congratulate the efforts of Research Foundation for Science, Technology, and Ecology and International Federation of Organic Agricultural Movement and Magda Ayolet for taking enormous steps to bring out the documents related to the use of neem oil in agriculture for preventing fungal infections. So after submitting all this evidence, the European Patent Office identified that there is no novelty, there is no inventive step, and they revoked the patent. So that is again a victory to India. Next slide, please. This case study of Basmati patent. So this is very interesting. We need to learn a lot from this Basmati patent. The United States Patent Office granted a patent to a company called Rice Tech for a strain of Basmati rice. You all know about Basmati rice. So from Punjab, we get an aromatic rice. And this is a tradition of India and Pakistan. And for centuries, the farmers in this region, they developed and they nurtured and conserved distinct varieties of this Basmati rice to suit to different taste and needs. So especially biryani and curd rice made up of Basmati rice, the taste is ultimate. In the year 1997, in its patent application, the company Rice Tech also acknowledged that good quality Basmati rice traditionally comes from northern India and Pakistan. Indeed, in some countries, the term can be applied to only the Basmati rice grown in India and Pakistan. However, the company claimed that they have invented a novel Basmati rice that has high quality, and the government of India, while opposing this patent, appealed only for 3 claims out of the 20 claims made in the original patent application of Rice Tech Incorporation. The 3 claims are the specific starch index, the specific aroma, and the grain dimension. So it is to be noted that the World Trade Organization agreement does not require countries to provide patent protection to plant varieties. It only requires countries to legislate so that the plant varieties are protected in some manner and not necessarily through patents. So in spite of India giving all the evidence, the United States being a strong proponent of patent protection of plant varieties allowed the patent application. So the patent application of RiceTech has been given. 3 strains developed by RiceTech are allowed patent protection and they're eligible to label its strain as superior basmati rice. Therefore, in basmati rice, RiceTech altered the strain through crossing with the Western strains of grain and successfully claimed it as an invention. And the case is an example of problems illustrated in TRIPS with regards to patenting biotechnological processes. Next slide, please. So far, we have seen about patent. Now we will see about the second intellectual property right, that is called as copyright. Copyright is a legal term used to describe the rights that creators have over their literary and artistic work. A book, a music, a painting, a sculpture, a movie, a computer program, database, advertisement, map, technical drawing, all of them fall under the category of copyright. You can't copyright an idea, but you can write down an original speech or poem or song and get a copyright. Once someone creates an original work of authorship, so original work of authorship is abbreviated as OWA, the author automatically owns the copyright. But registering with the Copyright Office gives the owner a head start in the legal system, so it is compulsory. Copyright is a legal term to describe the creator rights. The conditions for registration are based on 1, originality, 2, creativity, and the duration of copyright protection is lifetime of author plus 60 years. What all covers under copyright? As we have seen, books, essay, computer of compilations, artistic work, drawing, painting, logo, map, chart, photograph, architecture work. In drama, screenplay and drama. In music, musical notes. In sound recording, the compact disc. In cinematography, visual recording, including sound recording. All this comes under copyright. Next slide, please. Now we will see about a trademark. What is a trademark? So, a trademark is a sign capable of distinguishing the goods or services of one enterprises from those of other enterprises. Uniqueness. Trademark date back to ancient times when artists used to put their signature or mark on their products. Most of the Hindu gods, you can see at the end it will be written Kondal Rao. Okay, so trademark protects logos, sounds, words, colors, symbols used by a company to distinguish its service or product. Trademark examples include the Twitter logo, the bird flying, McDonald's Golden Arch, the font used by Dunkin. Although patent protects one product, trademark may cover a group of products. And this Trademark Act governs trademark infringement and service marks. Next slide, please. It is important to register a trademark because it protects business and consumers alike. I will give you an example. A California-based PayPal, they have filed a case against Paytm, which we are all now using, in Indian Trade Office, in Indian Trademark Office, for using a logo like its own. So the logo of PayPal and Paytm has some similarities. Paytm's logo is likely to cause confusion among the public as it is similar to two-tone blue color scheme like PayPal. So the trademarks are unique, they are distinctive, they cover devices, brands, headings, labels, names, signature, words, letters, numerals, shape of goods, packaging, or color combinations. So a trademark has to be very strong. So What is a weak trademark? A weak trademark is not distinctive, especially when it faces improper description of the goods and services. What is a strong trademark? A strong trademark is short, simple, memorable. It is timeless, consistent, instantly recognizable. A good trademark is versatile, allowing you to extend into different jurisdictions and products or service lines. The trademark registration are based on uniqueness, based on distinctiveness, and duration of trademark protection. So at the end of 10 years, you may have to renew your trademark. Next slide. Now, we have seen about patent, we saw about copyright, we saw about trademark. Now we are going to see about industrial design. So an industrial design constitutes the ornamental or aesthetic aspects of an article. How does an article look? The design may consist of three-dimensional features: the shape, the surface, or the two-dimensional feature, the pattern, line, color. So the next intellectual property right is geographical indications. Geographical indications and appellations of origin are signs used on goods that have a specific geographical origin. Like for example, Madura Malli, Mysore Malli, Madura Masal Dosa, Tirupati Laddu, Tirunelveli Alva. So all this, they have a specific geographical location and possess qualities, a reputation or characteristics that are essentially attributable to that place of origin. Most commonly, a geographical indication includes the name of the place of origin of the goods. Next slide, please. Now we are going to see the next intellectual property right, that is called trade secret. Trade secrets or intellectual property rights on confidential information that may be sold or licensed. The unauthorized acquisition, use, or disclosure of such secret information in a manner contrary to honest commercial practices by others is regarded as an unfair practice and a violation of the trade secret protection. Trade secrets are a company's intellectual property that isn't public. Nobody knows about it and has an enormous economic value and carries information. It may be a formula of a medicine, or it may be a recipe of a food, or it may be a process used to gain a competitive advantage. Next slide, please. What are the qualifications of a trade secret? Companies must work to protect proprietary information actively. Once the information is in public domain, then it is no longer protected under Trade Secrets Act. According to law, assets may be tangible or intangible, and a trade secret can involve information like related to business, finance, technical, economic, scientific, and engineering. I can give you one example. The formula of Coca-Cola is a trade secret. Nobody knows it. If you put a keyword in Google, how does Google search the algorithm? So that is a trade secret. Nobody knows it. Although a patent is public, trade secrets remain unavailable to anyone except the owner. Next slide, please. Now we will see some of the violations of intellectual property. So we have seen about intellectual property. We saw what is intellectual property. We saw the types of intellectual property. Now, if you violate, what happens? The significant violation of intellectual property consists of infringement, counterfeiting, misappropriation of trade secrets. So these are the different types of violation of intellectual property: infringement, counterfeiting, and misappropriation. So creating a logo or name meant to confuse buyers. So we have a number of medicine, hyphen. So both sound alike. So the buyer, the patient gets confused. The buyer is confused, thinking they are buying the original brand. Recording video or music without authorization or copying copyrighted material. See, we take many books from our library and immediately we Xerox the entire book cover to cover. So, but this is against Copyright Act. Copying another person's patent and marketing it as new patent, that is very dangerous. Manufacturing patent goods without a license to do that. Since intellectual property cannot be bought, sold or leased out, it often provide protection equal to the real property ownership. If there is a dispute, then the property is confiscated and monetary damage is taken care of. Next slide, please. Now, the government of India is encouraging applying for patents. So what are all the government schemes that are available? The Indian government has come up with a wide range of startup kits and startup funds over the past 18 months to empower startups in India. Several exemptions have been given to the startups, like intellectual property protection fees has been reduced. The qualifying startups under the Startup India scheme, so they alone are eligible for enjoying this patent protection fee for startup. It has come down at 80%, while for trademark the fees is reduced to 50%. So if you want to have a patent, if you have it as a startup, then it is commercially very viable. Further, a startup can avail expedition examination facility at the patent office very fast, wherein the disposal of patent application can take place within 12 to 18 months from the date of filing. So usually it takes 3 years. So, but you can get it in 1 to 1.5 years. Hence, the startup IP protection is not as costly as it would be for non-startup people. Next slide, please. The government of India has launched a list of startup schemes which fall under different ministries and departments. I will just read out the various schemes for startup. Number one, Startup India and Make in India. So you might have seen this Make in India becoming very popular now. Next, expedited patent examination. So if you are a startup, then your patent application will be examined very fast. 80% discount to startup. So if you are a startup, so in the entire publication, you need to commit only for 80%. Startups intellectual property protection, support for international patent protection in electronics and IT. The schemes of the Ministry of Medium and Small Scale Industries, accelerating the growth of new Indian innovations and Cell for IPR protection and management. So these and all are the various schemes of the government for helping startups to come out with patents. Next slide. So far, we have been seeing what is a startup. Now we need to define what is a startup. A Startup India is an initiative of the government of India. Startup India program was launched in the 16th century. Sorry, on 16th January 2016. It is intended to build a strong ecosystem for nurturing innovation and startups in the country, drive sustainable economic growth and generate large-scale employment opportunities. The government of India, through this initiative, aims to empower startups to grow throughout India in the field of innovation and design. Next slide, please. So who shall be considered as a startup? Now, it should be registered as a private limited company or as a partnership firm, or it must be a limited liability partnership or a one-person company. Next slide, please. See, a company formed by splitting up or reconstruction cannot be considered as a startup. So a company that is 10 years old, no, cannot be considered. A company whose financial year turnover is 100 crores, not to be considered. So a startup should have an innovative product, process, or service, should work for the development and improvement, and should be able to deliver. Next slide, please. What is a startup intellectual property? So the intellectual property for startups include copyright, trademark, and patent. So when you are starting a business, if you get a patent, then it is very easy rather than getting it late. So a sound IP strategy from the beginning can also help attract investors, suppliers, partners. And a startup seeks protection for invention, for the logo, for the business name, for the software. Patent protects an invention. Copyright protects a software. Trademark protects the brand name and logo. Next slide, please. One of the participant is asking for my PowerPoint. So you can get the PowerPoint from the principal of this KMP college. Thank you. So what are the reasons to secure intellectual property rights for startup? Why should a startup go for intellectual property right? Number one, see, there may be a bigger company. He may see your product and immediately he can come out with a duplicate product and he will benefit from your idea. So if you want to protect your idea, you will have to go to an IP patent. When you successfully gain legal rights, you take a copyright, you take a patent, then you are creating a rebuttable perception that the property belongs to you. So you will be saying, this is the drug and I have patented it. So you can also say, this is a patented medicine. In other words, when another company infringes on your intellectual property, you sue, the courts will presume that an intellectual property belongs to you unless the other company proves it otherwise. So getting an early patent is very important. Next slide, please. Protection from infringement suits. So somebody may claim this idea or this product is already there. It's my product. So to protect. So it is a key ingredient. It gives you security. And based on this patent, you will be able to get a better investors. Next slide. See, there is a deadline for getting intellectual property. So initially it was 1 year. But now in America, they have made it that who gets the patent first, so he will be first considered. So this came in the year 2013. So United States has moved from first to invent system to first to file system. You may be the first to invent, but a person who invented it fourth time, he may be the first to file. So he will be getting the benefits of this intellectual property rights and protection. Okay. Next slide, please. What are all the common mistakes that the startups make in case of this intellectual property? Number one, undervaluing of intellectual property. See, intellectual property accounts for a larger percentage of a company's value. The more successful a company is, many companies, especially startups, they find this filing of an patent is very costly. Maintaining of a patent is very costly. So if you don't have an IP strategy, that is why the government of India is giving for startups a lot of concessions in filing patents. So if you don't have a IP strategy for a startup, then marketing, supply chain, financial aspects, they all have to be developed as per the intellectual property plan. So if you don't have that plan, you are exposing your intangible assets to expensive infringement lawsuits. So somebody may already start your product and he may be producing it, again going to the court of law, fighting and getting it. It's all very difficult. So there must be a solid intellectual property plan to maintain your intellectual property assets. Next slide, please. See, if you are a team of engineers who invent, then there is one legal team so that protects the invention. So the creator and the designer, they must be in touch. So only if they are in touch, the intellectual property of the creator or the inventor can be protected. So what will happen if you don't protect? I can give you one example. The Coca-Cola. The formula of Coca-Cola, the recipe is kept in a vault. It is in a secret, vault in Atlanta, in Georgia. So only 2 people know about it. Only 2 employees know about the full formula of Coca-Cola. Actually, the formula was given by a pharmacist. So maintaining the confidentiality is very, very important. And for that, there must be an agreement signed. And that is called suppliers non-disclosure agreement. So in this case, you must be very careful in dealing with the formula of a very important product, Coca-Cola. Here, this formula becomes a trade secret. Next slide. See, you have, before starting with your product, you will have to do a trademark search. So if you're not searching it, now there are digital methods of searching it. If you're not searching it, then tomorrow you may have a product, but somebody will claim that it is their product and it will lead to a lot of lawsuits. So we need to know about intellectual property, because intellectual property is a unique selling proposition, USP. So today the world is very competitive, very dynamic. So in this world, this knowledge and awareness on intellectual property management is very, very important. It helps create a sustainable and defensible differentiator for the startup, creating a high entry barrier, good value for the venture, high priority. So these and all are the reasons. Next slide, please. Now we are coming to the fag end. Next slide, please. What is IP management? What is an intellectual property management? Effectively managing an enterprise intellectual property portfolio helps to protect the company, and for this, there must be a strategy. So that strategy is called management. So each and every startup should have 4 policies. Intellectual property policy on acquisition, on exploitation, on monitoring and enforcement. So these and all are the 4 policies that are required for IP management. So what is intellectual property acquisition? So you need to use the technique that is available with some other company, and that company has patented it. So now you have to go for IP acquisition. So the enterprise must be carefully examining the cost and benefit of patenting and formulate a strategy on patent acquisition which is sensible, giving their budget. Next is when the intellectual property is exploited. So now it is a day of commercialization. So IP protection is very important. When you're going for joint venture, you must be very careful in this policy of intellectual property exploitation. You should have a policy on IP monitoring. So you should monitor the competitor's activity, what he is doing, and you should identify if there are any infringers, and you should stay away from infringing the rights of your competitors. And enforcement, so to avoid loss incurred by the presence of counterfeit goods and high cost involved in IP disputes. So there must be a thorough monitoring force for IP monitoring and IP enforcement. So all this put together, it is called as intellectual property management. So this topic is a very big topic. At a student point of view, whatever is possible with relates to intellectual property rights, importance of intellectual property management, understanding the intellectual property rights that are required for a startup. So with this 3 title, I have given an overview about IP. So please get interested in this topic, be aware and beware of the updates on intellectual property. So the time taken for filing an intellectual property right, that is patent, is quite high. The cost is also involved. So unless and until you are aware, unless and until you are interested, so then it will be very difficult. So please be interested in this topic. This topic is much debated on the website. It is available in public media. Please take time to read it and be intellectual property rights literate. Thank you one and all. I thank the management for this wonderful opportunity, and I thank the students, all the 63 students, for their active participation. And I am grateful to the participants from other than this KMP college. So I thank you for your involvement, commitment, and for joining this session. Thank you one and all.
Thank you, sir, for impressive and informative session. Now it's time for the Q&A, in which anyone from those who are actually present can ask any questions to the speaker, or else, in case of any internet issues, please put your questions on the inbox. Thank you.
And that will be better. There are some noise disturbances, so if anybody wants to ask any question, you can put it in your chat box. And so I will be able to say this is a topic that has to be discussed at length. So if there are questions, please put it in your chat box. I will be able to privately reply to it. Thank you.
Sir, actually, there are some questions on the inbox, so please go through it.
Ooh. How do I obtain a patent? And so that is one question that is being asked. So there are patent facilitators. So you will have to identify the nearby patent office, and you can go in person or you can visit their website. So there are patent facilitators, you can contact them. So they will be able to guide you step by step in drafting your patent application. So first and foremost, the idea that you have, whether it is patentable or not, so that will have to be clearly find out. And then when you contact the patent facilitators, so they will help you. Apart from that, the government of India, especially for startups, they have a number of patent guidance cells. So if you contact them also, they will be able to take you. Now, discussing the process of applying patents step by step, it will take another 1 hour. So I don't think we will be having time for it. You can search, and it is all available step by step with what you call examples. in the net and also in the official website of intellectual property rights. So please go through it. In case if you have any difficulty, you can get back to me. Thank you.
Sir, I have a doubt. Normally, the patent process, how long it will take, sir? What is the minimum and maximum period of time for one patent?
Sir, if you are having a startup, it will be done within 12 months to 18 months. But if you're not having a startup, if you're doing it individually, then it depends on your patent examiner. So application and publication can be done very fast. But it depends on the patent examiner, the questions he poses and how you defend yourself. And these things will take a lot of time. Following up with the patent office is very important for expediting. And again, there are some schemes where you can accelerate the patent examining process. Roughly, if you take, it takes around 3 years.
Okay, sir.
Thank you.
Does anyone want to ask any questions?
Students, you can join in groups and maybe with the help of your family members, you can also learn about entrepreneurship and about how to start a startup. So many of the students of late, once they complete, they join hands together. Some 3-4 students joining hands together, they come up with a startup. And from a startup point of view, if you apply for patents, it is very easy. The guidance, the fees is reduced by 50% to 80%, and the time is also much reduced. So getting a patent through the startup is the right way and the best way, the cheapest way, and the time-saving way. Thank you.
All right, is there anyone really wanted to ask any question? Please ask right now, or else we are. Thank you, sir, for your response to the queries.
Thank you.
Now we would like to call Ms. Rajisha Madam, Assistant Nodal Officer, IEDC, to propose vote of thanks.
Good evening, everyone. It's been an honor to deliver the vote of thanks on behalf of our KB College of Pharmacy. First and foremost, I would like to thank our speaker, Dr. V. Gopal sir, Registrar and Principal, the Mother Teresa PG and Research Institute of Health Science at Puducherry, for its outstanding presentation on intellectual property rights. It was very informative and worthwhile. Thank you, sir. I thank our management, Principal Dr. J. Nandakumar sir, Vice Principal Dr. Harish Babu sir, AO Mr. Shahjahan sir for their support to make this webinar a huge success. I also thank IIC and IEDC coordinator Dr. Sena Cates and IIC members Mr. Anthony Rohit Rajan for their coordination. Also, my sincere gratitude to our beloved Unikrishnan sir and Mr. Eldu sir of our IT department for their technical support. Thanks to all HODs, teaching and non-teaching staff and students for their participation. Special thanks to Ms. Joshna and Mr. Praveen for their meticulous anchoring. Once again, thank you and wishing you a very great evening. Thank you all.
Thank you, one and all. Have a great day.
Thank you, sir. Thank you for your excellent presentation.
Thank you all for your participation. Now everyone can leave.